A royal dilemma. Prince Harry's American dream under scrutiny. Prince Harry, once a beloved member of the British royal family, now finds himself embroiled in a legal battle over his American residency. The crux of the matter, his US visa status. Harry's decision to step back from royal duties and relocate to California with his wife, Meghan Markle, has thrust his immigration status into the spotlight. The situation is further complicated by the fact that releasing an individual's visa information is a serious offense under US law. The Department of Homeland Security, the agency responsible for immigration matters, guards this information closely. The unauthorized disclosure of such sensitive data is considered a federal crime, punishable by law. Despite the legal ramifications, a conservative think tank, the Heritage Foundation, has been actively pursuing the release of Prince Harry's visa records. Their efforts have ignited a fierce debate about the public's right to know versus an individual's right to privacy, particularly when it comes to personal and confidential information like immigration records. The case has captivated the attention of people on both sides of the Atlantic, prompting discussions about transparency, accountability, and the limits of public interest when it comes to the private lives of public figures. The veil of secrecy. Why visa information is strictly confidential. Visa information is not just some bureaucratic formality. It's a treasure trove of personal data that the US government is obligated to protect. This confidential information encompasses an individual's immigration history, travel records, health status, and even their criminal background, if any. The rationale behind this stringent protection is multifaceted. Firstly, releasing such sensitive information could expose individuals to identity theft, harassment, or even threats to their safety. Imagine the chaos that could ensue if someone's home address, travel plans, or medical history were to fall into the wrong hands. Secondly, maintaining confidentiality is crucial to preserving the integrity of the immigration system itself. If individuals feared that their personal information could be easily accessed or exploited, they might be less likely to cooperate with immigration authorities or even apply for visas in the first place. This could have far-reaching consequences for international travel, business, and cultural exchange. Lastly, and perhaps most importantly, the right to privacy is a fundamental human right, enshrined in international law and upheld by the US Constitution. Protecting visa information is not just about safeguarding data, it's about respecting the inherent dignity and autonomy of every individual. The Heritage Foundation's crusade unveiling Harry's past. The Heritage Foundation, a prominent conservative think tank based in Washington, D.C., has emerged as a central player in the saga of Prince Harry's visa status. The organization filed a lawsuit demanding the release of Harry's immigration records, arguing that the public has a right to know the basis upon which he was granted entry and residency in the United States. Niall Gardner, a vocal figure within the Heritage Foundation and a staunch critic of Prince Harry's political views, has been particularly outspoken on the matter. Gardner has publicly questioned whether Harry's admission to the US was handled properly, suggesting that the prince may have benefited from preferential treatment due to his royal status. He has also raised concerns about Harry's past admissions of drug use, detailed in his memoir Spare, and whether those admissions were fully disclosed during the visa application process. They argue that Harry, by virtue of his celebrity and his outspokenness on various political and social issues, has made himself a public figure subject to greater scrutiny. They maintain that the public has a right to know if he has been forthright about his past and whether he has complied with all relevant US immigration laws. A judge's decision redacted documents and lingering questions. In a move that surprised many legal experts, a federal judge presiding over the case ruled in favor of the Heritage Foundation, ordering the Department of Homeland Security to release Prince Harry's immigration records. However, the judge also acknowledged the sensitive nature of the information and stipulated that the documents be heavily redacted to protect Harry's privacy and safety. This decision has done little to quell the controversy surrounding the case. Critics of the ruling argue that it sets a dangerous precedent, potentially paving the way for future invasions of privacy based on flimsy justifications of public interest. They contend that the redactions, while intended to protect Harry's personal information render the documents virtually meaningless for the purposes of genuine scrutiny or accountability. The Department of Homeland Security, caught in the crossfire, has expressed reservations about the ruling, citing concerns about potential harassment and security risks to Prince Harry should his full immigration file be made public. They have maintained that they followed all legal procedures in processing Harry's visa application and that there is no evidence to suggest any wrongdoing or preferential treatment. Section 5. Expert opinions navigating the labyrinth of immigration law. The complexities of US immigration law and the unprecedented nature of Prince Harry's case have prompted a flurry of analysis from legal experts, each offering their interpretation of the situation and its potential ramifications. Charles Cuck, a prominent immigration attorney, has publicly criticized the judge's decision to even consider the Heritage Foundation's request, arguing that it undermines the very foundation of visa confidentiality. Cuck has emphasized that releasing an individual's visa information is a clear violation of federal law, regardless of their public profile or political affiliations. He has warned that this ruling could have a chilling effect on immigrants and visa applicants, potentially discouraging them from seeking entry or residency in the United States for fear of having their personal information exposed. Clayton Cartwright, another immigration expert, has speculated that Prince Harry might be residing in the US on an A1 visa, a special category reserved for diplomats, foreign government officials, and their immediate families. Cartwright points out that this type of visa would explain the lack of findings in the unredacted documents and align with the DHS's protective stance. Section 6. The A1 visa. A golden ticket or a precarious perch. The A1 visa, often referred to as the diplomatic visa, offers a unique set of privileges and limitations. It grants holders immunity from prosecution and exemption from certain taxes, but it doesn't offer a pathway to citizenship. This means that while Harry can live and work in the US, he wouldn't be eligible for a green card or US citizenship through this visa category. Another crucial aspect of the A1 visa is its dependence on the visa holder's continued employment or affiliation with the sponsoring government. In Harry's case, if he were indeed on an A1 visa, his ability to remain in the US could theoretically be jeopardized if his relationship with the British royal family were to deteriorate to a point where they withdraw their sponsorship. This dependence on a foreign government for one's legal residency can create a sense of vulnerability and uncertainty, highlighting the precarious nature of even the most privileged visa categories. Section 7. The Department of Homeland Security's stance protecting privacy and preventing harm. The Department of Homeland Security, or DHS, has found itself at the center of the storm, tasked with balancing the court's order with its obligation to protect Prince Harry's privacy and safety. In their official statements, the DHS has emphasized its commitment to upholding the law while also safeguarding individuals from potential harm. They have argued that releasing Harry's unredacted visa information could expose him to harassment, threats, or even physical danger, given the intense media scrutiny and polarized opinions surrounding his every move. The DHS has also highlighted the fact that Harry has never been found to have violated any US immigration laws and that there is no evidence to suggest he poses a threat to public safety. Their stance reflects a broader challenge faced by government agencies in the digital age: how to reconcile transparency and accountability with the need to protect individual privacy and security in an era of heightened surveillance and information sharing. Section 8. Public interest versus personal privacy, striking a delicate balance. The Prince Harry visa controversy has reignited a long-standing debate about the delicate balance between the public's right to know and an individual's right to privacy. On one hand, advocates for transparency argue that the public has a vested interest in knowing whether public figures, especially those who express strong political views or benefit from public funds, are abiding by the law and acting with integrity. They contend that scrutiny is essential for holding those in power accountable and preventing abuses of power. On the other hand, privacy advocates argue that everyone, regardless of their status, is entitled to a certain degree of privacy, particularly when it comes to sensitive personal information like immigration records or medical history. They warn that eroding privacy protections in the name of transparency can have a chilling effect on free speech, discourage individuals from seeking help or support, and create a climate of fear and suspicion. Section 9. Conclusion. A saga unfolding, the future of Harry's American journey. As the legal battle over Prince Harry's visa status continues, its outcome remains uncertain. The redacted documents have only fueled further speculation, leaving many questions unanswered. Will the Heritage Foundation succeed in their quest for full transparency? Or will the courts ultimately uphold the sanctity of visa confidentiality? The case stands as a stark reminder of the challenges posed by the digital age, where the lines between public and private are increasingly blurred, and the right to privacy often clashes with the public's insatiable appetite for information. Regardless of the final verdict, the saga of Prince Harry's American journey has sparked a vital conversation about the limits of public interest, the importance of safeguarding individual privacy, and the challenges of navigating a world awash in information.